Hi, welcome to Codebreaker. My name is David Merlin. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis, believe it. Here's a great example of it. This is a happy document. Happy document number one. This is a happy document. I'm happy about this document. So few things along the many years in law, the 3 or 4 times I've actually seen justice occur in the 29 years I've been doing this. There are certain times when there's great cause to be happy, and this is one of them. And for those people who know me, they'd be proud of me to hear that I actually took time to smell the roses along the way, the fruits of my efforts. And while the first attempt at remedy with this document, using this document, was unsuccessful, everything after this is directed at getting exactly what we didn't get in the first attempt. The first attempt was service of this document upon a particular individual. And there will be other attempts made with this document to stir the conscience of government. And when you say that, of course, that's oxymoronic. You're not stirring the conscience of government. You're shocking the spine of the public servant with the with the imminence of handcuffs. Yes, it's the coward that trembles. It's nothing glorious you cause in the other party. And this is a great example of, there are certain times I get a call, I'm contacted, hey, I have this particular problem, and we consult, and I get the facts of the case. Now, there was, I don't know, it might have been like 2.5 years with the privacy committee. A private group had me on a conference call Tuesday and Thursday for 2 hours each day for 2.5 years. And all I would do is take calls from individuals who had controversies, municipal, state, and fed. I couldn't answer every one. Of course, nobody knows everything. But in certain instances, there was abuse of procedure, of the constitutional rights. And so I would look for these breaches. It might not have anything to do with the law that they're using to either sue or prosecute the individual on the phone speaking to me, but if they blow procedure in a certain way, it can still constitute a crime. So I don't have to know everything about every law that's at issue in a particular case. If a particular breach occurs, it doesn't matter what the law of the case was. It matters what laws apply to the judge and the prosecutor that should prevent them from doing that. And most often you'll find those laws include handcuffs, meaning it's a misdemeanor to do that. It's a gross misdemeanor to do that. It's a felony, Your Honor, to do that over there. Don't go there. And you want to know these parameters. That's what I use. And the reason this is a happy document is because I was happy to do it. It only took me a couple hours to talk myself into doing this job. A guy called me. I was on a conference call with 2 other people. One of them was this defendant. And he has a very particular dilemma. And as you see here over here, let's call this the syllabus for the heck of it. You see, that's what we're going to cover today. And he says, I have this particular problem. And what I'm doing is I'm outlining the bricks of the house. What are we going to build something out of? I was indicted, 7 counts, tax evasion, filing false tax returns or something in Kentucky. And It wasn't like he filed international bills of exchange for trillions of dollars like some of these fruits do. These fruits? The anti-tax movement. Pete Hendrickson tree fruit. So I've been indicted, and I'm on record with certain documents with the government, and I need to know what you might do. I know you're not an attorney, Dave. Okay, thank you. You're right, I'm not an attorney. I can't give you legal advice. How do I view your situation? Here's how I view it. That was the question. I think I'm innocent. Here's what I have that could prove it. And I'm listening to this evidence. I'm asking the questions, and so that I can make an argument for the guy that he's innocent of tax evasion or failure to file. I can't remember what in this particular case. We'll see later, but we're looking at it from the standpoint of, should he be prosecuted? And worse, is there even a good reason to prosecute him in the first place? They're public servants over there, and they're supposed to seek justice first, not just flex their muscle first and drop their foot on somebody. So it's one thing to say, yeah, he's innocent. Hey, you missed this over here. Look at this. He's innocent. You should know this. And it's altogether another thing to say, excuse me, but you knew this. You knew he was innocent, and you indicted him? Is that right? That's a totally different scenario. Totally different. That's what this document is about. That's why I'm happy to have written it. Because when you step over that line of prior knowledge and criminal intent, and you prosecute someone, servant breath, what does the law, what does Congress have to say about it? Congress, that's federal. Well, you're using the mail when you falsely prosecute somebody, aren't you? Servant prosecutor breath, servant breath. They have to say yes to that one. Well, we're going to see how that makes it federal. It's part of the overall scheme under federal statutes you should have known about. Right over here, we're looking right here at criminal complaint. Whose criminal complaint is that? Well, it's not the government's. That's up here. That's with the indictment. It's my criminal complaint. Why? Because you're prosecuting somebody that's innocent. Oh. Yeah, servant breath, that's something to consider. Is it a crime to prosecute somebody who obviously doesn't believe they've violated the law? Specifically in this instance, failure to file false tax returns on a state level, Kentucky. And what we're going to do is look at my response. September 4th, 5 p.m. Pacific. I'm in Seattle. I get a phone call. 2 other people on the line. One of them is this man, and I've obscured all personal information in this entire document because it's irrelevant. Docket numbers, times and dates, whatever, it doesn't matter. What we're looking at is what is the fabric of the action against him if in fact the government knew in advance that he was innocent, and if more than one person in government is seeking to prosecute him despite that prior knowledge. That's the question. What would you do, Dave? How do you see this? September 4th, and as you see, I've had a month to think about this. September 4th, 5 p.m., I get a call. We consult for 40 minutes, and then at 6 p.m., I had an hour-long conference call that I do on Monday evenings, so I couldn't look at the indictment in my email until 7 p.m. Monday, September 4th. Tuesday, September 5th, 26 and a half hours later, 9:30 p.m., and I had emailed this completed 27-page criminal complaint to the parties, along with this assembled collective of exhibits. I put these together, put the exhibit cover page on each one of these, and drew upon them in the criminal complaint that I wrote about what they were doing to him for the purposes of this man going on the record with his own criminal complaint. And if he believes this, here's a verified, meaning notarized, document that he can get originals of anytime he wants. He can get all the originals first. Make like 20 originals, sure. And then when you serve them on somebody, get a certificate of service. That's what this document is for. It's to show the government that I know what you're doing. You're prosecuting somebody that's innocent. What were you thinking? A plus B equals C. What were you thinking? That's what this document's about. So in 26 and a half hours, let's call it 24 because there was 8 hours of sleep in there, probably 3 periods of meditation, about an hour or an hour and a half, about exactly what I wanted to say in the complaint and how far into certain aspects of the defense I wanted to articulate in the complaint here in support of his allegations. And so a lot of thought went into it. You can count that if you want, but let's just say, hey, Dave, what do you think? And 24 hours later, bingo, this is what I think. So call this, basically you call somebody that has a specialty, and I say, yeah, I got an idea. And 24 hours later, you get this out of me. And it's the fabric of malicious prosecution as it relates to laws that prohibit malicious prosecution. Doesn't look like this law prohibits malicious prosecution, Dave. Well, you have to interpret law. I learned how to interpret law from judges, reading hundreds and hundreds of cases where judges describe what they have to do when they interpret law. Hundreds and hundreds of cases. I've read over 4,000 decisions. It's a recurring theme. Well, here's what we do when we interpret statute, and that's what I do. So we're going to see why prosecuting somebody that you know is innocent, prosecutor breath, is a crime. And we're going to see how bad of a crime, what is it, a high crime? Is it a misdemeanor? Is it a traffic ticket? We're going to see. This is a happy document. I was happy to write it. In 24 hours, they had their response. What do you think, Dave? This is what I think. In 24 hours, think about it. 24 hours. He got this document from me. It's 120 pages. 27 pages of it is the criminal complaint that I wrote, composed for him, And the rest is exhibits. These exhibits. We're going to start with the evidence. Exhibit A, his letter of rescission or revocation. It's a document he placed on public record saying, here's what I believe about the law. Remember, it's Kentucky, and it doesn't matter who he is. It doesn't matter I don't care. None of that matters. This is a lesson about what does the law say about malicious prosecution. And this is a happy document. Don't forget that. Now, he's citing Article 1, Section 2, Clause this, Clause that, Statute this. Here's a U.S. Supreme Court case. Doesn't sound like sui juris, man upon the land type of stuff, He might do that at some point in this. This is not my document. This is something he had already had on record when they prosecuted him. So here is, what is this? Why would I rely on this document? This is a document that draws upon federal statutes. Here's a Ninth Circuit case from 1983, Bothke versus Floor Engineers. With the IRS's broad power must come a concomitant, that means adjoining, responsibility to exercise it within the confines of the law. Well, in Kentucky, they've argued you can't have clear explanations of the laws. Well, okay, are we going to overturn this case? The court has emphasized that no official is above the law and that broad powers present broad opportunities for abuse. Oh, I'm shocked. So anyway, he's citing court cases, saying here's what I believe and here's what you have to do to perform. Here's Supreme Court cases that are relevant to what I'm doing. Allgaier versus Louisiana, very interesting case for the purposes of the health care bill. You can't buy insurance outside your state. 1897, Allgaier went all the way to the Supreme Court against Louisiana, arguing that this law in Louisiana that says I can't buy insurance outside of my state is unconstitutional. And that Louisiana law was stricken in 1897. And so the health care bill and its requirement you can only buy within your state, F-A-R-C-E, I think it's a C in farce, right? So anyway, I'm relying on Supreme Court cases here. I'm this defendant, and I've gone on record with the basis for my belief that the law imposes no duty upon me to file or to pay. Probably. I don't know what his instance was. I just know this constitutes evidence of innocence. Because if you have a good faith misunderstanding of the law, you are not willful. And this is an indictment for willful failure to file. And here's proof of his mailing of all that to the authorities. And here's another letter that he served on them. Again, he's citing case law and Title 28 of the United States Code. Okay, he's right in the law for most of this. Any person required to deduct and withhold any income tax provision, and then he cites tax code statutes. He's on record with his interpretation of the law, state and federal. And this is what he served on state authorities. And they indicted him afterward. So it goes on and on. This is somebody else's concoction. There's a bunch of different stuff in here. None of it is what I teach. None of the statutes cited in here are the basis for any of my arguments. Period. I have a totally separate, unique set of conclusions and research base. However, he's on record. And this is December 2016, very recent. I think the other one was earlier. Now, Exhibit B. Here's the indictment. They indicted him. Uh-oh. But they never asked anybody, including him, do you really believe what the stuff you did was legal? Do you really believe that? They never bothered to ask. Shouldn't that be part of the investigation if his belief that he was violating the law is an essential element? Gosh, that's a good question. So count 1, 2, 3, 4, 5, 6, 7 in this year on this date, and look, he's got 2. Here's KRS, Kentucky Revised Statutes, willfully filing or making false tax returns, or failure to pay a tax. And I think this is all about it's one or the other. We don't really even need to focus on whether it's about the tax returns or the failure to pay, because these are pretty much identical. And we got this indictment from the grand jury on this date and on these years, 2011, 12, 13, 14. Okay, we're racking up the charges against this guy. And we never even bothered to investigate what his beliefs are. When in fact, if you don't believe you have a duty, you're innocent. Exhibit C. Look at that. Publication 17. IRS Publication 17. Tax Guide for Individuals. Here is the cover of the publication and the internal page of the cover page, or of the publication. from 1993 through 2016 telling you that your services are your cost. Oops. 1993. The basis of property you buy is usually its cost. This is part 14 of publication 17. Part 14, basis of property. See, I know this by heart. And this is about compensation for services. Discusses how to figure your cost of property and covers the following: property you purchase, let's see, that you receive in exchange for your services, right there, okay? 1993. The rest of it is much better quality. This was before Al Gore invented the internet, and so I had to photocopy scan publication 17. But in 1994, January, I began using it as Exhibit A in litigation for a bunch of people, 5 of whom went all the way to the Supreme Court. And so they amended this. But look here, 1993, the basis of property you buy is usually its cost. The cost is the amount of cash and debt obligations you pay for it and the fair market value of other property or services you provide in the transaction. Your cost also includes, meaning we're talking about your cost, the fair market value of the services you provide in the transaction is part of your cost. It reads just like 26 CFR 1.83-3G. I have a 9th Circuit case and an 11th Circuit case where the exchange of briefs is done and the government was unable to get into the language of this regulation despite the fact they've had this since I photocopied this in 1993. This is a 1993 scanned PDF photocopy of 93 that I took of publication 17. And they still can't talk. They referred to this regulation, but they won't talk about the language. Why? It says the amount paid is the value of any money or property paid. Well, if my cost is the value of any property, including my labor, I don't want it included in profit. And they'll penalize you for asking. 1994. And they say the same thing. And the fair market value of services you provide in the transaction. Oops. This covers property you receive in exchange for your services, part 14. So I started using this as exhibits in tax court, 1994, January. Bunch of people. So in 1995 they amended it. Look at that. It's different. The amount of cost, the amount you pay in cash or other property. Now it sounds just like 1.1012-1A, another regulation that applies to your paycheck. And so they're all over it. Your cost is your services, and they had to amend it because I was using it as an exhibit for all these people. And so anyway, scroll through this at your leisure, get my materials, you'll find this in there. 23 years worth of them saying your cost is property you pay in cash, debt obligations, or other property. That's right out of 1.1012-1A. Your cost is cash or other property. So anyway, it goes on and on right through 2016. They're telling you your cost is cash or other property or your services. Look at this. Let me see. Here's what year was this one? 2004. You can start drooling now. The cost is the amount you pay in cash, debt obligations, other property, or services. Well, then what the hell are you telling me in tax court my services are not my cost? This publication goes to every household in America. It's the tax guide for individuals, the one they want you to have. And I'm going to scroll right to 2016 so that you say, what the hell are they trying to prove here? They tell us every year your cost is services, and then if you get to tax court and you say so, they'll penalize you thousands of dollars for frivolity under tax code section 6673, frivolous tax court petition. And here's 2016, debt obligations, other property, or services. The cost is the amount you pay in services, right there. and you go to prison if you believe it. Right there. Back to my disclaimer, anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. 23 years worth of this. If you believe this, you go to prison. And it's the IRS's #1 publication. Oh, man. James R. Back went to prison. 16 months sentence for filing Pete Hendrickson tax returns. As an Alyeska pipeline technician, you'll see he was making over $125,000 a year, putting 20+ thousand into his 401k every year. Filed Pete Hendrickson tax returns, and that all came to a crashing halt. But in this memorandum from the government's trial memorandum, the government takes the time to explain what innocence is when somebody is charged with willful failure to file, willful tax evasion. What the hell was he charged with here? Statement of the case. Here he is. Here's what he's bringing in: $150,000. Look at that. Every year. Minus his 401k, and here's his taxables. Filing false tax returns. 2007. 2008 tax return. False. 2009, 2010, 2011, failure to file. Look at that. So this is prior to trial. It's their trial memorandum. Here are the elements of the offense. And look what they cite. 9th Circuit Model Criminal Jury Instructions, Your Honor. Here's what it means to be guilty or innocent when you're charged under 7206, false tax documents. First, now look, pay very close attention. It is so important. I'll show you a couple things they leap over, but the leap is over the moon. It's enormous. In order for the defendant to be found guilty of that charge, the government must prove each of the following elements beyond a reasonable doubt. First, the defendant made and signed a tax return for blah, blah, blah years, and he knew it contained false information. Second, the return contained a written declaration that it was being signed subject to the penalties of perjury. Third, in filing the false return, defendant acted willfully, meaning he had a legal duty, he knew and believed he had a duty, and failed to perform the duty. They skip over had a legal duty. Number one, they never have to prove that. A matter is material if it had a natural tendency to influence or was capable of influencing the decisions or activities of the IRS. Okay. But they didn't state specifically they had to prove, when they say he acted willfully, they got to prove he acted willfully. Yes. One of those is you got to prove he's required to file that document. False information is material if it had a tendency to screw with the IRS. Okay. Let's see. Also charged with failure to file, 4 counts. Another model criminal jury instruction. First, listen to this. Okay, this is it right here. In order for the defendant to be found guilty of that charge, the government must prove each of the following elements beyond a reasonable doubt. First, the defendant was required to file a tax return. How are you going to do that without showing the jury all of the laws? How do you do that? First, the defendant was required to file a tax return for that calendar year. How are you going to do that without showing them 6012? Anybody that has gross income over that equals or exceeds the exemption amount has to file a tax return. Well, okay. He's charged with filing false tax documents. How does Section 83 operate? In your conclusion, it's false when he said he earns 0. They can't talk about that. I just threw the law as a wrench into the gears. You can do that. It's the law. Second, the government has to prove the defendant failed to file for that year. Yeah. Third, in failing to do so, that he acted willfully. We got to prove that too, Your Honor. Acted willfully. That means they have to prove he was required to file. You're not required to file unless you have gross income that equals or exceeds the exemption amount. Section 6012A says so. Did I have gross income? If you say yes, how did Section 83 operate in your conclusion I had gross income? They can't talk about it. We're just in Exhibit D. This is the government's explanation of what innocence is. Now we're getting down to it. In order to prove that the defendant acted willfully, this is a jury instruction, Ninth Circuit Model Criminal Jury Instruction 9.42. In order to prove that the defendant acted willfully, the government must prove beyond a reasonable doubt that the defendant knew federal tax law imposed a duty on him and the defendant intentionally and voluntarily violated that duty. How am I going to know that? When, look at Kentucky, you file a motion to dismiss the counterclaim saying he's not entitled to clear explanations of the law. The government must prove that the defendant knew. The government can't even prove that it knows you have a duty. Servant breath. A defendant who acts on a good faith misunderstanding as to the requirements of the law does not act willfully. If he doesn't act willfully, he's not guilty. So if he acts on a good faith misunderstanding as to the requirements, he does not act willfully, even if his understanding of the law is wrong or unreasonable or from the planet Mars or the planet Patriot movement. Nevertheless, merely disagreeing, which this guy did not do. He went on record with a letter full of citations about the law and Supreme Court decisions. He didn't merely disagree. Nevertheless, merely disagreeing with the law does not constitute a good faith misunderstanding of the law, because all persons have a duty to obey the law except the government, whether or not they agree with the law. Yes, that was my rhetoric thrown right in there because I prove it on a daily basis. You heard my disclaimer. You're looking right at the face of it. Thus, in order to prove that the defendant acted willfully, the government must prove beyond a reasonable doubt that the defendant did not have a good faith belief that he was complying with the law. Well, they got to prove also that he was required. That's number one. Number two, that he knew and believed he was required. That's number two. And number three, that he failed to do what was required. You got to start with number one. They jumped right over it. And listen, they go back to number one here, but then they try to get out of it in this paragraph. It's a leap over the moon. They cite Supreme Court cases that talk all about it, and then they jump all the way over it. Well, how do you cite Supreme Court cases and then jump over them? It's easy. We can jump over the moon. Citizen breath. Oh, okay. Duly noted. Start jumping. Section 7203 and 7206 of the Internal Revenue Code use the term willfully. In Cheek v. U.S., the Supreme Court set forth the following definition of willfully. Willfulness, as construed by our prior decisions in criminal tax cases, requires the government to prove that the law imposed a duty on the defendant, that the defendant knew of this duty, and that he voluntarily and intentionally violated the duty. Right. Start with prove that the law imposed a duty. Start and stop right there. That's what I do. I start and stop right there because I know exactly which provisions to argue. I've been doing it since 1993. This same definition applies equally to all tax offenses, misdemeanors and felonies alike. See U.S. v. Pomponio. Thanks. Citing U.S. v. Bishop. Great. In other words, if you know that you owe taxes and you do not pay them, you have acted willfully. Well, what if I don't know that I owe those taxes? I mean, the 1992 version of the tax code and regulations I learned on from the Commerce Clearinghouse, I took it to the grocery store 6 months ago. I weighed it on a vegetable scale. 22 pounds of rice paper. And they don't have to tell me what it means. In other words, if you know that you owe taxes, well, I don't know anything really. All I know is what I've been threatened with. March 1st? I'm Ronnie Doy. I'm H&R, but we're H&R Block. Come on down here. We'll keep your head from falling down the trough when the IRS comes looking. So all I know is what I've heard. I don't know anything. I've heard rumors. In other words, if you know that you owe taxes, nobody does. In Kentucky, they're arguing against giving you clear explanations of the provisions. They govern how to tax your paycheck, and they say in the Taxpayers' Bill of Rights you're entitled to clear explanation of the laws. Which one is it? In a failure to file tax return prosecution, the government is not required to prove an intent to evade or defeat a tax. Yeah, but you got to prove it's a tax. That means you got to get into the law. But may instead prove an intent to disobey or disregard the law, which may be the intent not to file the return rather than the intent to defeat or evade the tax. Okay, we're splitting hairs. Get to the part where the law reaches an American that only sold his labor. Her labor. Doesn't matter. A defendant's views regarding the validity of a tax law statute is irrelevant to the issues of willfulness. But the defendant's good faith misunderstanding of the law is relevant. We just heard that. Okay, so that's the government, that's the meat. The reason I included this brief, this memorandum from the government, in this submission for this man. Here's a memorandum from U.S. Attorney General, May 10th of 2017. It's fairly recent. Jeff Sessions' memorandum, and we look at this. And we look at this only for the purpose of this line right here. First, it is a core principle that prosecutors should charge and pursue the most serious, readily provable offense. Exactly. So when I have hands down evidence of crime of any degree, misdemeanor, okay, it doesn't rise to the most serious, but when I have evidence of the most serious and it's obvious, this memorandum from Jeff Sessions says the reason for this is this policy affirms our responsibility to enforce the law, is moral and just, and produces consistency. What a concept. And the last exhibit is a page from the Special Investigators page of the Kentucky website. That's all. Okay, now we come to the criminal complaint. What criminal complaint? Well, they know he's innocent. He's on record with a clear explanation of his beliefs. He drew upon Supreme Court decisions and never received a rebuttal from the state except a prosecution. So that was his answer for his good faith misunderstanding of the law. When the government says it's innocence, that means you're innocent. Okay, well, I'm innocent. Okay. How can you tell? Well, we're citing Supreme Court cases. Citizen breath. Okay, I believe you. Well, I can't believe it in Kentucky, because they look right at that and say, okay, well, this man's wife took that indictment to the prosecutor's office with a note to read to the receptionist, who would not date stamp any copies. And so she left one copy there. And the statement said, and this was in the week following the September 4th phone call to me, "This is a criminal complaint to the Department of Justice against Prosecutor Larry Cleveland. This is a very serious matter. I need Mr. Cleveland to know that if I haven't heard from him letting me know that the indictment against so-and-so has been quashed and revoked by the close of business tomorrow, Friday, such a date, I will file this complaint for a capital offense against him and others with the Department of Justice and seek criminal charges against him. Send the notification to my email address. If the indictment is quashed by tomorrow, I will not file this complaint. Served on a certain secretary, received at 1:27 in the afternoon." Okay, so the wife means business. And that was the ploy, that look over this criminal complaint, please. You're the prosecutor. Because I'm alleging that you violated federal criminal statutes in prosecuting an innocent person who happens to be my husband, she says, by serving this on his behalf. It's a complaint from him, notarized, meaning verified criminal complaint. 18 U.S.C. 4 requires you to report felonies to the government. Capital offense alleged herein. Holy smoke, death penalty. 18 U.S.C. 241. Can I prove somebody is eligible for the death penalty and is reasonably suspected of having violated the statute in a way that would justify the death penalty? This 18 U.S.C. section 241? And that's what you're to ask as we go through this criminal complaint. Have I made a case, and it wasn't my name on this, but I'm not going to write something for somebody else to sign that's frivolous. I'm not in the movement, after all, and so I don't do that. But how do I see this? I said to myself, and in the consultation, I said, I kind of see it this way. I think it's reasonable, personally, if it were me, this is what I would do. I would allege this. And so I wrote this, and 26 and a half hours later, he had this. And here it is, a criminal complaint for one violation of Section 241 of Title 18, conspiracy against rights, a capital offense. Comes now, Joe Lunchbucket, reporting felonious misconduct, and Exhibit B is the indictment. And all exhibits are incorporated by this reference. Any and all emphasis employed herein is added, and the counts begin on page 24 at paragraph 4.1. The counts that I allege against whom? Daniel P. Bork, Commissioner of Revenue for Kentucky. Richard McKenna, investigator, under the charge of Daniel P. Bork. And John Doe number 1, the prosecutor that took the case to the grand jury. That's whom. And here we have the quote from the Jeff Sessions memorandum. Here's what your job is, because this is a criminal complaint to the Department of Justice. And it's a happy document. Paragraph 1.3. Here's what you're going to find here. Overt acts and exhibits, page 3. Authorities, page 7. Counts, page 24. The authorities start on page 7 and go to page 24. Yeah, man. That's like 16 pages of authorities. I'm not dragging you into the weeds with all that case law. I'm throwing a blanket over a couple of simple questions that everybody should ask when somebody is prosecuted. Do they believe they're guilty? And if so, Did the prosecution even bother to investigate that, or are they just going to steamroll through the jury process and get the guilty plea through the grand jury process, and get the guilty plea by threatening you? And then the conclusion, page 25. Defendants Daniel P. Bork, Richard McKenna, John Doe, who know the complainant to be innocent of Kentucky state tax evasion, are engaged in an ongoing violation of 18 U.S.C. 241 by conspiring to unlawfully abduct or otherwise restrain, as outlined in 18 U.S.C. 1201 kidnapping, the complainant in a way that constitutes a capital offense. It's not the complainant's fault. Conspiracy against rights. If two or more persons conspire to oppress, threaten, or intimidate any person in the free exercise and enjoyment of every right or privilege secured to him by the Constitution or laws of the United States. Let's see. They shall be fined in this title not more than 10 years or both. Or if such acts include kidnapping or an attempted kidnapping, they may be sentenced to death. You can pause the video right here and read that slowly for yourself. When somebody falsely prosecutes anybody, brings them up on false criminal charges, and more than one person is acting to succeed against the innocent person, is an arrest and imprisonment under a false charge a kidnapping. If the prosecutor and the judge know you're innocent, if the prosecutor and the cops know you're innocent, and the cops are going to testify or their reports are used as evidence, are they people who are conspiring against your rights to liberty? Of course they are. If I were to kidnap you, I could use a gun, a baseball bat, a drug, a threat against your family, and take you to another location. But I don't have the law on my side. Well, if I'm a prosecutor or a cop or a judge and I'm involved with others, when I know the law does not reach you, but I'm trying to get you confined, maybe in county jail or federal prison, that's a conspiracy against your rights. That's unlawful. Definition: kidnapping. Whoever unlawfully seizes. They had to commit a 10-year felony under federal law to kidnap me or to seize me. So I think it's an unlawful seizure. Whoever unlawfully seizes, confines, inveigles, decoys, kidnaps, abducts in any way somebody, a person. The person is willfully transferred in interstate commerce, or any perpetrator uses the mail or any means or facility in interstate or foreign commerce, shall be punished by imprisonment for any term up to life. And if somebody dies, they can be punished by death. Well, nobody died. And so we go back to 241, there's an attempted kidnapping. That qualifies for the death penalty under 241, not under 1201. And it's not yet a kidnapping, it's an attempted kidnapping. He's not been arrested at the date of this document. So if the complainant, I'm reading paragraph 1.5, if the complainant, meaning if I did this, if the complainant conspired with others to unlawfully act to kidnap, transport, and imprison any of the defendants, an indictment is a certainty, and the prosecution would issue a press release as to whether the death penalty is on the table. Complainant would likely be allowed to plead guilty to the conspiracy charge in exchange for doing away with the kidnapping count. He would be sentenced to 80 months in prison. The degree to which the sanctions resulting from the criminal complaint, or this complaint, if any at all, are the measure of the law, and the degree to which the pains expectedly visited upon the private citizen who so acted eclipse in severity those imposed against these named defendants who are public servants. Meaning, watch. What you do to these public servants when I've proven they're qualified for the death penalty, Are they going to get sanctioned? They're going to miss a paycheck? Are they going to, there's an attorney here in the caption. Is he going to be disbarred? They're going to be charged? They qualify for the death penalty. Because they're public servants, only blank will happen to them. Fill in the blank. You know? Let's see. Criminal complaint against the actors. Okay, table of contents, overt acts and exhibits. These are the exhibits. We already reviewed them up here. They were the beginning of today's tutorial. And I'm listing them in my criminal complaint regarding the overt acts of these defendants. Defendant Daniel P. Bork, the Commissioner of Revenue for Kentucky, Richard McKenna, his investigator, and John Doe, the prosecutor in the Commonwealth of Kentucky. Commissioner of Revenue, prosecutorial discretion, intentionally omitted from any and all training resources at the Kentucky Department of Revenue any reference or training relevant to Kentucky Revised Statutes provisions cited herein or relating to these tax code provisions made state law by reference in Kentucky Revised Statutes. So Section 83 is going to be part of the argument here. They know I never even owed a dime because Section 83 hasn't operated. I can prove it. I've proven it against the Fed already. So this guy walked right into it. But it's a happy document. So he knows all this. Richard McKenna is an expert on Kentucky and federal tax law who knows and understands everything about the provisions cited herein, but has chosen to ignore the law and to participate. What it says is he's an investigator. He better know everything about the law. And so here he is accused of being an expert on everything pertaining to the instance of the defendant, the guy that's been indicted. He knows everything about the law. There's nothing he does wrong, and he knows I'm innocent. How do you argue against that? You have to come in and say, I don't know what I'm talking about most of the time, Your Honor. Ignore that. Okay. Defendant John Doe knows that the complainant is innocent. He's the prosecutor. And so we're making these allegations. These are the overt acts of these defendants. And now we're going to get into, here's the definition of innocence. We already reviewed this memorandum from the James R. Back trial. We already read that exactly. I'm making the case for he's innocent by the government's own definition, and these guys know it. And here's I think this is a newspaper article they published against him, corrupting the jury pool. Look at paragraph 2.11. The defendants have arranged to pollute the jury pool by posting false and or whatever stories online. Yeah. The authorities. Okay, the subject indictment is fatally defective. For nowhere does it say that the conduct complained of violates any law of any kind. Oh, that's pretty interesting. That'll cause them to amend the indictment right there. Go back and read the indictment. It doesn't say he violated the law. Here's an attempted kit, and then we get right into, okay, now here's why we're talking to you. Forget the defect in the indictment. Here's the other issues. Here's an attempted kidnapping in progress with a broader conspiracy to deprive the complainant of his liberty and other rights concomitantly lost due to a felony conviction, like loss of firearm rights, maybe rights to vote, depending on your state. Complainant is innocent because the law does not impose an income tax on the fair market value of personal services. That's a pretty good point. He's innocent because the IRS said for over 23 years that your services are your cost. He's innocent because he clearly lacks in all respect any trace of criminal intent. And number 4, defendants will admit that they simply exclude personal services from cost as defined by law through some policy without permission to do so, because the law says your cost is any property or cash or other property. And they simply say, accept labor out of thin air. Your cost is any money or property. Oh, except labor. Out of thin air. It's a policy. It's a desire. And it's contrary to the language of the law. And they're stealing. That's what that means. Kentucky revised statutes. Here's the charging statute. Intent to evade payment of the tax. Okay, willfully fails to file. And here's the Kentucky state law saying gross income means gross income is defined in Section 61A of the Internal Revenue Code. Thank you very much. 61B, however, says for items specifically included in gross income, see Section 71 and following in Part 2. Well, that's 71 through 90. 83 is in there. I think maybe 71 through 91. I can't remember. But 83 is in there. I'm real certain I can count. And here's the IRS's Chief Counsel Office. Section 83 provides for the determination of the amount to be included in gross income. Not the IRS, not the courts, Section 83. And I go through the case law that says Section 83 applies to all compensation. It explains how to tax it. It governs the taxation of compensation. There's nowhere to go. You have to get into it. There's no escaping. It's a black hole of tax law. You have to get into it. There's no choice. Okay, what does it say? It says only the excess over the amount paid is gross income. And case law says the same thing. Tax court. The excess over the amount paid is gross income. What's the amount paid? The value of any money or property. And we got a regulation that says apply Section 1012 to figure your cost. Okay, your cost is cash or other property under Regulation 1.1012-1A. 1.1011-1A says that's also known as your adjusted basis, not just your basis. It's known as the adjusted basis also. It only assigns a synonym. The basis in 1012 is also known as the adjusted basis. And then this regulation 1.1012-1A tells you what to do with that adjusted basis in 1011. The amount which remains after the adjusted basis has been restored to the taxpayer constitutes the realized gain. You have to restore the adjusted basis, your cost, to yourself. Then you calculate the gain. What's left is the gain. That's why they won't talk about Section 83. So you deprive me of that. You know I'm innocent. I never owed a tax, and that's the argument made here. And here's all the case law right through Supreme Court 2008. 5 cases the government won in the Supreme Court saying saying the term any is all-inclusive. I didn't have this in the 90s. I didn't think I had to teach them how to read the term any as all-inclusive, and always lost. They just said, well, we don't do that with labor because, and I said, well, where's your authority to exclude labor? The regulation says any money or property, and they'll penalize you for asking. Well, now I got all these Supreme Court cases, 5 of them, and 4 tons of appellate cases that agree with those Supreme Court cases, concurring right with them, saying, yeah, any is all-inclusive. You bet. Any and everywhere. Watch my other tutorials, and you'll see these reviewed slowly. Watch the Section 83 tutorial. Go to wevgovt.com, my website, federal income taxation page. You'll see all that on the all those cases. And here's publication 17, quotes. Taxpayers' Bill of Rights. You're entitled to clear explanation of the laws and everything the IRS does. Wrong. Supreme Court, 1937. The taxpayers were entitled to know the basis of law and fact on which the commissioner sought to sustain the deficiencies. Wrong. We're in Kentucky. You don't have a right to clear explanation of the laws. Wow. So anyway, I drag him into this. You deprive me of Section 83, racketeering and extortion, but most importantly, It's a conspiracy against my rights, including an attempted kidnapping. That rings the bell. What bell? The death penalty bell. And I repeat, the fourth reason that he's innocent. Because they deprived him of Section 83 to say he owes in the first place. And then we get to the next argument. Mens rea. He lacks criminal intent. It's right down here. Criminal intent. So now we're going to, it's obvious he's on record with his own statement, and you indicted him anyway? And this is all about criminal intent. The very recent cases out of the Supreme Court, 2015, 2009, 2016, U.S. Supreme Court. They have to have probable cause as to every element of the offense. Consequently, this is the Ninth Circuit, 1994. Consequently, to have probable cause to believe that a crime has been committed, an arresting officer would have to reasonably believe that you're guilty. Well, part of reasonably believe you're guilty is reasonably believing you believed you had a duty. It's part of it. And they skip it because they'll beat you up after they get the indictment, threaten to indict your spouse, so they get the plea agreement out of you and you go to prison. That's the game. But they don't even investigate what you believed. And this guy's on record with his beliefs. So no, he doesn't have criminal intent. And here's how fundamental it is on the Ninth Circuit. In 2015, the Supreme Court said in Alonis, this decision right here, and it's caused a wave of litigation through the criminal justice system. It's a standard that's been revived. It's always been there, but it's been overlooked by the government and public defenders and the criminal defense lawyers in that industry. And yet you see in 1994, the Ninth Circuit, it is fundamental that a person is not criminally responsible unless criminal intent accompanies the wrongful act. Oh, is that right? So they've known all along. And the Supreme Court says over and over again, here's the Ninth Circuit again, 2005, the existence of mens rea or criminal intent is the rule rather than the exception of the principles of Anglo-American criminal jurisprudence. Thus, except in unusual circumstances, we construe a criminal statute to include criminal intent element, even when none appears on the face or in the language of the statute. Well, if you're presumed innocent, you're presumed to believe you don't have a duty. How come they didn't investigate? Because they didn't presume him to believe he had no duty. What's worse, they're in possession of evidence he does not believe he has a duty. That's the turning point right there. I outlined at the beginning of the tutorial. Prior knowledge, that's different. They know he's innocent and they're going for it. Here's the next issue. The tax is not imposed by clear language, lenity, or lenience. And here's the case law that says you can't be forced to speculate as to the meaning of penal statutes. This is 2001 case. At a bare minimum, in cases such as this one, in which the complex statutory and regulatory scheme lends itself to any number of interpretations, we should be inclined to rely on the traditional canon that construes revenue-raising laws against the drafter. When the tax gatherer puts his finger on the citizen, he must also put his finger on the law permitting it. They can't. I'm making the argument that lenience is the rule. They know this, but they're trying to bring him to prosecution anyway. Here's the Kreitzer annotation. Paragraph 3.16, U.S. versus Kreitzer, and all the cases that cite it. Kreitzer says, it is well settled that when the law is vague or highly debatable, a defendant actually or imputedly lacks the requisite intent to violate it. In this instance, is the law vague or highly debatable? Oh, I don't know. Are you in violation of Section 83 or in compliance with Section 83 when you included my paycheck in gross income? Servant breath? They can't even talk to you about it. That's worse than highly vague or highly debatable. It's off limits. I have loaded this criminal complaint with proof that he's innocent and reasons to believe he's innocent that aren't so much born of proof, they're born really of the fact that the government can't deny squat. It is well established that the statute must give a defendant fair notice that his contemplated conduct is forbidden. Specifically, an individual may not be prosecuted for violating tax laws when the statutory provisions at issue are vague or highly debatable, or the governing law is completely unsettled by any clearly relevant precedent. Oh, you never get away with that. This is America. What was that judge thinking? You can't have that. You can't have this either. Back to my disclaimer. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. A tax must be imposed by clear and unequivocal language. Where the construction of a tax law is doubtful, the doubt is to be resolved in favor of whom upon which the tax is sought to be laid. Supreme Court says so. No, it doesn't, Your Honor. Spoken like a public servant. Albert Einstein, the hardest thing in the world to understand is the income tax. Oh, we understand it now. Yeah, all property is a cost. Yeah, citizens of the United States are only named in a regulation, which is irrelevant to a Kentucky state indictment, so it's not in this complaint. But, yeah, we know the law now, and we can prove it. So here are the violations of federal criminal statutes, the beef, okay? What charges are we talking about here? We're talking about one charge. Now, look at this. At all times complained of, this is a preliminary paragraph. It applies to everything that follows. At all times complained of, each and all defendants acted with criminal intent and were entirely aware of clearly established law which excluded complainant's conduct from conduct prohibited by the charging statute. Paragraphs 2.1 through 4.2 shall be deemed incorporated into and alleged in each and all of the following paragraphs of this complaint and in relation to each and all defendants. A blanket statement saying I've already made the case, I've already told you about the evidence, I got my exhibits attached. You know all you need to know, and base everything I say hereafter on what I've told you. Here is the charging statute. Sentenced to death for conspiracy to kidnap or attempt to kidnap in a conspiracy against rights. Count 1, and there's only one count. Defendants: Daniel P. Bork, Commissioner of Revenue, Kentucky; Richard McKenna, the investigator for Daniel Bork; and John Doe, the prosecutor, know the complainant to possess full rights to liberty and to privacy, which you lose when you go to prison, but have chosen to contrive and to act in concert in a conspiracy conducted in whole or in part through the U.S. Postal Service, because I wanted to trigger the essential elements of the statutes, to deprive the complainant of said rights without a lawful basis or authority to do so in a plan that includes an unlawful abduction or other restraint outlined in 18 U.S.C. 1201. This conspiracy against rights of the complainant is in violation of 18 U.S.C. 241 and is a capital offense. There. Everything about this 120 pages led to that paragraph. Nothing complicated about it, was it? Everything was directed toward making a case in a criminal complaint. You're not trying to prove their guilt. You're trying to prove why your suspicion of guilt is reasonable. That's all you're doing here. And this is why I think it's reasonable to accuse these people, used loosely, of the capital offense of conspiracy with an attempted kidnapping. The conclusion. Severe sentences are not the only inconvenience with which the defendants should concern themselves now that they are felons. Reasonable suspicion that a felony has been committed translates into or equates to the right to arrest the felon with any necessary force. Really? You got any case law that says so? Yeah. This is every case as of 2012 in the LexisNexis database. You'll find a quote from each one of these cases on wevgovt.com on the citizens arrest page of the website. 5.2. An innocent American now stands falsely charged in an ongoing attempted kidnapping and conspiracy planned and operated by the defendants and their accomplices yet unnamed. Compare what we know would happen to a private citizen if they were to engage in such conduct against another, how stiff the penalties would be, how high the bail would be, held pending trial, perhaps allowed to plead just to 241's 10-year max. The news articles, video footage, all the other stuff that comes in tow with all of this. But they'll not be sanctioned in the least because fill in the blank. What is the reason for the difference between what would happen to me and what would happen to them? So he gets into them. You can read this at your leisure. Pause the video if you want. I'll back up here. Hang on. Pause the video if you want. And I scroll. Pause the video if you want. He's just concluding okay, up on the soapbox. That's what you do in the conclusion. But this is very important. A reprimand, disbarment, prosecution, an actual prison sentence. More? If not, why not? More? Yeah, that means guillotine. Causing a death or injury isn't an essential element of the 241's different level of sanction. Just conspiracy and attempted kidnapping, and the defendants have had every chance and reason to refrain but stayed the course without blinking. They've been served with this document, and they didn't dismiss quash the indictment. That's fine. Like I said, that's I'm 1% done with you, and all I've done is serve the prosecutor. So they can laugh. Oh, here's the citizen. Look, it's the citizen with a cute little complaint, and they have their notary. Come here and look at this. Give me a cup of coffee. Bring me a cup of coffee. Come here and look at this. The citizen was here. Isn't this cute? They can say all of that they want. They can't think down the road. They should be asking, gosh, it's a death penalty complaint against the prosecutor and the commissioner of revenue and some investigator. Should we think about this? They don't even think down the road. Is the citizen who served this on us just now, that cute little, she came in here with it, she's darling. Is she 100% done? Or is she just getting started? Well, I don't know. Is there fruit in having just gotten started? Gosh, I don't know. Maybe the state bar would like a copy of this criminal complaint for the death penalty against somebody practicing in the state of Kentucky. Maybe the local newspapers would like to know. You start there and never stop until everybody and their real estate agent has a copy of this package. And ask the question, do you think we should execute the commissioner of revenue? Well, I don't know. Why would you ask such a thing? Well, I have this complaint here. He sure looks guilty. And talk it up. Radio stations. Oh, yeah, we got to get this guest on. Tell me about your complaint. Thank you. Thought you'd never ask. Wouldn't that be great? I'm 1% done. I'm not 100% done. You file something like this, you go for it. Bacon is flapping in the wind. He's under indictment. And his wife, yeah, they loved the document. They were thrilled with this criminal complaint. And we're consulting, and they're going to serve it on more people. I'm not an attorney. I didn't give anybody legal advice. I gave them my opinion in the form of this document saying, I think this is what happened, and I think this is the fabric of law that applies to what happened. I think this is a pretty darn nifty way of saying it. and here it is. This is in the box. Very little rhetoric at all in these 27 pages, because Congress speaks for you. A conspiracy to take your liberty by more than one person. In a conspiracy to take your liberty. In that definition of kidnapping in 1201, whoever unlawfully decoys, inveigles, seizes, whatever, abducts, the death penalty. I've been in this 29 years. As an advocate, 25 years. And I've never heard the combination of 1201 and 241 for the death penalty for a malicious prosecution. That's what drives us up the ladder. And you see in this document that really, I let the law do most of the talking, and it comes down to one count. Conspiracy against rights with an attempted kidnapping. It comes down to just this one count. It's such a happy document. And so, Sheriff, I'm, let's say, perhaps the wife of this gentleman that's been indicted, approaches the sheriff. I have this, they won't quash the indictment. I've complained to the Department of Justice. And what I want to know, since they're racketeering under state law too, I know that's a felony, I want to know that if you're not going to go out and arrest them, I want to know what door that I should bring them to when I arrest them and bring them to you. Where do I deliver these people when I arrest them? That's why all this case law is in here. Because just because the sheriff doesn't want to arrest somebody, it doesn't do anything to the fact that your suspicion is reasonable. Period. 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 So just because they don't want to arrest somebody doesn't mean they aren't duty bound to accept somebody into custody when you deliver them. And when I know where to deliver them, this is a happy document. Merry Christmas. It's 2:30 on Christmas morning, 2:30 a.m. You get on the floor in front of your Christmas tree and your children right now, and I'm going to put these handcuffs on you, and we're going to the FBI. Merry Christmas. This is a happy document. It's happy document number one. I think anybody that sees this should be happy. And I know a lot of people that see this will be happy to know that, you know, I'm on record with my good faith misunderstanding of the law. And it's one you can't even refute. It's based on statutes. And you convene a grand jury against me? You engage in a criminal investigation against me? How am I not to view that as an attempted kidnapping? It's in motion. You're conspiring to kidnap me. When the indictment is obtained, that's the attempt, because it'll be accompanied by an arrest warrant, just as this man's indictment was. How is it not a conspiracy with an attempted kidnapping and thus a capital offense when they indict somebody that doesn't believe they have a duty? Sherry Jackson lectured around the country. Former IRS agent quit the IRS, a decorated accountant and investigator. And they indicted her. Failure to file, or tax, I think it was failure to file. She obviously doesn't believe she has a duty. How are the people who did that not subject, and this is really the icing. The statute of limitations on a federal felony is 5 years. I can't remember off the top of my head what statute that is. The statute of limitations on a felony committed by a public servant in Washington State is 10 years. But an offense that is capital has no statute of limitations. And 241, conspiracy with an attempted kidnapping, is capital. For the rest of their lives, based on this complaint, and with the understanding they've not been indicted for this yet, they've not been arrested for this yet, they've not been charged and prosecuted for this yet, it's fresh. They're felons at large. With that understanding, you tell me, are they not subject to citizen's arrest for the rest of their lives based on this document? And there's no stretch in this entire document. The only thing that the perps could call a stretch, nobody reasonable could, but a perp would say, oh, you're really stretching it there to say a malicious prosecution is a kidnapping. Well, excuse me, but the private individual would use a gun or an axe or a drug or, whatever, pushing the back of a pickup truck. The prosecutor used guns, handcuffs, and buses in prison. But the fabric of their act is nonetheless a kidnapping. It's an unlawful abduction. Unlawful? Yeah, they had to commit a conspiracy against rights to liberty, 10 years in prison, to get the indictment. So yeah, it's an unlawful abduction. So, the icing for the rest of their lives. One who has committed the act of malicious prosecution, I feel, has committed a conspiracy against rights once you connect the dots. If they knew you were innocent, they, more than one person, they, if the prosecutor and the judge, prosecutor and the representative from the taxing authorities that has your file with all your misunderstanding of the law on record, they, the commissioner of revenue, whoever, state or fed, if more than one person knows you're innocent and they prosecute, death penalty. And for the rest of their lives, they're subject to citizen's arrest for all the time they spend without being indicted. No one has been able to tattoo in places you can't see in the shower and against their will these people with the law the way I just did in this complaint. Now you go back and you look at the quality of the pleading and understand they asked the question at 5 o'clock on a Monday evening, and at 7:30 the following evening, they had this document in hand with the completed array of exhibits in one PDF document with exhibit cover pages, and everything was done and ready to notarize. Call it 24 hours. That's another reason why this is such a happy document. It was an opportunity. Hey, Dave, what do you know about this? And it took me a couple hours, and I said, yeah, there's a few tools I could showcase on this project. And so I took out my opinion of what happened to this guy, and I said, this is what I think. And he and his wife read the document, and they said, it makes way too much sense, man. It's right on. And they filed it. So a criminal complaint for a capital offense over a malicious prosecution. You saw it here first. I'm really glad to give this to you as a tutorial. And you see it all right here. Certificate of service. Yeah, it was served. Everybody knows that everybody knows. And she read this to the prosecutor's receptionist and served this right on them. So anyway, enjoy the document, the drama, and be happy. Merry Christmas. For Christmas now, Daniel P. Bork, Commissioner of Revenue, and his investigator and the prosecutor. Merry Christmas. You can be arrested by 320 million gun owners at any moment for the rest of your life. for the rest of your lives, you three. Wow, that's a high price to pay for a prosecution of a tax protester, isn't it? Servant breath. Merry Christmas. That's what's under your Christmas tree. You are in handcuffs in front of your children. You are under the Christmas tree, servant breath, because anybody that wants to, Christmas morning, can walk into your house and arrest you and take you to the FBI and hand the FBI a copy of this complaint with your rusty carcass, and they can go on with their own Christmas. So that's the Christmas present you got for yourself. I'm proud and I'm happy to have gotten the assignment of articulating it for you, servant breath. And for anybody viewing this tutorial, okay, what can Dave do to a public servant in 24 hours? Look at this document from that standpoint. You listen to my other tutorials, you listen to morons barge onto my YouTube channel or my conference calls or whatever and lambaste me. They're from the movement, so they don't really know anything. And yet, to answer the question, what can Dave do in 24 hours to a public servant? Oh, malicious prosecution? Here's what. How much of this is it obvious? I already knew. I just plugged his facts into existing machinery that I've already got in-house, right here behind my eyes and above my ears. And bingo, 24 hours later, ready to go. So anyway, Merry Christmas, servant breath, and may all your Christmases be spent in handcuffs. Because, now look at the plea agreement. Okay, let's say we drop the conspiracy charge that carries kidnapping. And he pleads guilty to kidnapping and no conspiracy, because kidnapping only carries up to life imprisonment. Any term or life. Now, at least he's not going to be subject to the death penalty for this guilty plea. And we promise we won't ask for more than 15 years. So, servant breath, if you plead guilty to kidnapping without the conspiracy charge, the most you'll face is life in prison, and we won't recommend more than 15 years. Now, that's pretty civil of the prosecution. Or drop the kidnapping count and plead only guilty to conspiracy against rights without reference to kidnapping, so the most you'll face is the 10 years in prison. Right here. So there's a lot of ways out of this, but the guilty plea would be the easiest thing they ever got, because these public servants want to avoid may be sentenced to death. Right here in 18 U.S.C. 241. So look how easy it would be. Back to here's the rule of law. How much does it weigh? If I did this, there'd be a press conference. Are you going to ask for the death penalty? If a public servant does this, are they going to lose a paycheck? They're going to be reprimanded, sanctioned, vacation without pay? Are they going to be scolded? They're going to be disbarred? Climb the ladder? Are they going to have their heads chopped off? If not, why not? Talk to me. There's no excuse. They qualify for the death penalty. And the plea agreement would be the easiest one they ever got. And there's simply no excuse. So look again. It's obvious, and the memo from Jeff Sessions says the most obvious and severe charges. Okay, death penalty, this is pretty obvious. Go get them. Well, no, they're servants. They're public servants. Let's see what the difference is. And the rule of law? Are you going to go get them? Is anything going to happen to these people? Regardless of whether or not they're prosecuted, they can be arrested for the rest of their lives. Now, about the most obvious and severe charges. Most obvious, I just proved that it's easy to get a guilty verdict out of this. So that's another thing that weighs in favor of going to get the indictment, because the guilty verdict would be a piece of cake. So there's every reason for the DOJ to prosecute these people, and they won't be prosecuted. The client will settle for the quashing of the indictment. Oh yeah, great. That's all I'm in it for. Sure. Everything else is gravy. I don't believe they'll be sanctioned in the least. But he's got plenty in this document to make a pain of himself against these people for every step they take forward against him. He's leveled the playing field. What did you do when you learned you had been indicted for tax evasion? Well, I know I'm innocent, so I filed a criminal complaint for the death penalty with the Department of Justice. Does that sound like somebody that's guilty to you? Me neither. So the DOJ's got great reasons to prosecute. I gave them everything with this document. And as you go through this, pick and choose. I scrolled through it quickly. I'm not going to go through it page by page. I'm not selling the document. I'm giving away the approach to malicious prosecution. Include the death penalty in your criminal complaint. It makes your side of the argument much stronger. When you can say with prior knowledge, they know I'm innocent. What the hell are they trying to prove here? Well, here's what it earned them. Now, everybody in America that learns of this can walk in on them at the awards ceremony, or on Christmas in front of the Christmas tree, or at their daughter's volleyball game, and take that officer to the FBI, or whatever, whoever's going to be arrested. Look what they walk into using just the law. I've proven. Look what they walk into with a malicious prosecution. No one's ever connected these dots before. So anyway, again, a very happy document. I'm glad to give this to you, this approach, this breath of fresh air, this glimmer of, I'm not just waving handcuffs at the public servants with this document. I'm waving a noose. They don't even sound similar. And when you're preaching guillotine and death penalty, you're going to get a more diligent and captive audience than if you're just saying, oh, you should be prosecuted. Now you're talking death penalty, which means the right to arrest the felon in perpetuity. So here I am. It's my 80th birthday. You're coming with me in like the year 2038. It's permanent. So keep this document if you ever, want to put something on your bucket list. Just keep this around. I'm going to go arrest me a servant that committed a capital offense way back in 2017. Anyway, I don't give legal advice, but it's a ticklish notion. My name is David Merlin. I hope that you've enjoyed the tutorial. And it's not a new spin. It's an increase in RPMs on the same spin. Criminal complaints is what to do. File criminal complaints. I've got a course on how to write and file criminal complaints available on wevgovt.com. And there's another course there when you're done with learning how to file and write criminal complaints. Drive-by litigation. Get that course. It's the meanest thing I can do on paper until I wrote this document. This adds a new perspective to a malicious prosecution. And again, I'm happy to give you this, and I hope it makes you happy that look what somebody did. And in 24 hours, there's an advocate out there working for the people that's able to do this in just 24 hours. So, with that having been said, have fun, be fun, enjoy yourself, enjoy somebody else, and I'll see you in the next tutorial. Thanks for visiting Codebreaker. Take care.